Consulting. Eve has decades of experience implementing the Americans with Disabilities Act and other disability rights law through consultation, technical assistance, training, guidance, and enforcement. She has served as a senior federal government official at the Department of Justice Civil Rights Division, as the Director of District of Columbia Office of Disability Rights at the Burden Blake Institute, and in academia, nonprofit, and private practice. She also has experience helping entities go beyond compliance to include disability as part of their diversity, equity, and inclusion efforts. She's the co-author of a treatise and a casebook on ADA. Recent highlights of her work include, all right. Well, please give Eve Hill a hand.
Thank you. All right. So this is a little intimidating. I know lots of people here, some of the people I most respect in the space. So I'm like, oh, got to get it right. I want to do a visual description. I am a white woman with red hair by choice and wearing, black because that's my color, but fabulous shoes. And this is usually Lady Feingold's update on accessibility legal changes. And Lainey describes herself as a dolphin, and she describes me as a shark. But I think I'm more like Bruce the shark in Finding Nemo, who's really a vegetarian. So that's a little bit of the difference that you'll see today. I'm far too impatient to be a dolphin. Dolphins take a lot of patience. So we're going to talk a little bit about this is my roadmap, and it shows a road. Shocking. I'm very creative in the pictures. Why digital accessibility? What is digital accessibility? Then we'll go through the laws, the regulations, the guidance, laws and regulations on the way, and case developments and best practices to stay ahead of the curve. A few disclaimers. This is not legal advice. I can't give you legal advice. If you ask me a question, ask a hypothetical. The reason I cannot give you legal advice is because you will forget to tell me the key piece of the question. And I will be flip and give you an answer that sounds like it's the perfect answer, and it will not have that key piece of the question and therefore be the wrong answer. So we can hypothetical our way through some things, but don't take this back to your people and say, Eve Hill said she's going to sue you if you do this. It's not covering every case or every law. We don't have that much time. And a little bit about language. I got used to using people first language, person with a disability, people with disabilities, individuals with disabilities. But now more and more people prefer identity first language. So disabled people, blind people, deaf people. So I'm going to switch back and forth just to confuse everybody. What? Both okay? Or to show that they're both okay. Exactly. And questions are welcome. I really like this to be a conversation more than me going blah, 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 and you going yawn, yawn, yawn. So why digital accessibility? Why not? Digital accessibility is the bridge between the information, services, and goods that businesses and government entities and agencies need to get out in the world, and the customers that they need to get those information, services, and goods. Accessibility makes the connection between the two. So accessibility means customers. And people don't think of people with disabilities as their customers, unfortunately. And they are wrong, 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 wrong. People with disabilities are 16% of the world's population. That's 1 out of 6 of us, or 1.3 billion people with a B. So because of the size of the population, we have money. We don't all have a lot of money, but together we have money. In the US, not counting their friends and families and allies, people with disabilities have disposable income of approximately $490 billion. That's approaching that of African Americans. and discretionary income after taxes and basic living expenses of $21 billion. That exceeds African Americans and Latinos. Worldwide, the income of people with disabilities is larger than $3 trillion and disposable income greater than $1.9 trillion, including people's friends and families who may want to side with them in boycotting inaccessible websites. That's $10.7 trillion in disposable income. It's no joke to try and get people with disabilities to be your customers, and we will. And just to talk about, I work a lot with the blind, 43 million blind people worldwide, 295 million people with moderate to severe vision impairment. And that has been growing in the last 30 years by 50%. So that group cohort of customers is growing dramatically. And the number of people who've developed vision impairments went up 92%. So researchers predict that by 2050, 61 million people will be blind and 474 million will have moderate to severe vision impairment. Not a customer base we can ignore. And that's not counting people who are deaf and need captions, people with seizure disorders, people with manual dexterity disabilities, and people with cognitive disabilities, all of whom add to the numbers of people that we're talking about excluding from your customer base. Disability is equality in this world. We are online. We live online. We shop online. We work online. We are not in the same world that we were in 30 years ago. So digital access means equality. It means the ability for people with disabilities to have equal access to everything that the rest of us have. And it means privacy and independence. I do a lot of work in voting, accessible absentee voting. And currently absentee voting in many states is purely by pen and paper. And that requires a blind person to get a third party to come read the candidates and then just have the person tell them who they want to vote for. And you can see how well that would go over in my family, where some of us do not support the same candidates at all. They might by mistake check my vote. So digital accessibility also supports your diversity, equity, and inclusion efforts. We now talk about DEI, adding accessibility to DEI, but I don't want us to think about accessibility as separate from DEI. DEI, equity, and inclusion includes people with disabilities. People with disabilities are part of the diversity of our communities and need to be represented as part of the diversity of our communities. And accessibility is a baseline to help that happen, but you also need diversity, equity, and inclusion efforts to include people with disabilities in your workforces. But accessibility is the baseline. You can't draw us in and then say, well, you really can't do your job, or you really can't access this program. And then digital accessibility, my favorite part of it is it's a civil right. And this is a picture of people who use wheelchairs and other mobility devices crawling up the steps of the Supreme Court. That was a protest that we did. Digital inaccessibility, on the other hand, is exclusion from civil rights, is exclusion from access, is exclusion from the goods and services that we all take for granted, the information that we all take for granted. It's exclusion. It's not an inconvenience. And why do we care about digital accessibility? Well, people talk to me about this a lot when they say, why are there so many website lawsuits? Why? And I say, there are 200 million active websites in the world, 1.9 billion total. Those are the inactive ones. And more websites are added every single minute. So, and on the top million homepages, 96.3 have accessibility barriers, according to WebAIM for 2023. 96.3%. Basically all of the top million homepages have accessibility barriers. And that's an improvement. Let's call it just an improvement over 4 years ago, when it was 97.8% had accessibility barriers. So it's a target-rich environment, one might say, if one were a lawyer in this space, and I do. And and these are not tiny little things, and it's not just a few little accessibility barriers. It's an average of 50 errors per page, which is down shockingly from 50.8 in 2022. So we're inching our way towards the disability justice that that Peter talked about last night. So what's digital accessibility? Well, most of you know better than I. But it's not just about websites. I'll talk about websites a lot, or I'll refer to websites a lot, but I don't actually mean just websites. It's about mobile apps, it's about kiosks, it's about virtual reality, enhanced reality, it's about software, it's about copy machines, it's about coffee machines. It's about all the things that we use that are electronic or information technology. And it's about the technology and the content. This is something that people forget in their trainings all the time. Yes, the PowerPoint platform that you're producing it on is accessible, but the PowerPoint itself has to be accessible too. So we either forget to have an accessible platform, or we forget to have accessible content, at which point none of it works. And accessibility, we tend to look at WCAG 2.1 level AA these days. But it's sort of a mishmash because the government is very slow. So they've mostly adopted WCAG 2.0 for Section 508, for example. And we still have to hear from the Justice Department about what standard they'll adopt for ADA accessibility. We'll see. But everybody agrees that WCAG 2.1 level AA satisfies the accessibility obligations if you meet them under the laws. But the real definition for me that I use is that it allows people with disabilities to access the same information and engage in the same transactions at the same time with equivalent ease of use. So it's not that you can get the information during regular business hours when everybody else can get it in the middle of the night in their bunny slippers. It's not that you should have to jump through 3 hoops where I only don't have to jump through any. All those things are what makes accessibility really accessible. So it's a combination really of accessibility and usability. And it's also not about just, we think a lot about blind people or with people with low vision. It's about people with all kinds of disabilities, blind and low vision, deaf and hearing loss, manual dexterity disabilities, cognitive disabilities, speech impairments. Whatever the disability, it has a digital accessibility component to it. Dyslexia, learning disabilities, lots and lots and lots of disabilities are affected by this. And people who don't think of themselves as having disabilities are affected by digital accessibility. Okay, so how do we get to digital accessibility? Again, you know more about this than I do. I'll just run through them. Alt text for images, labeled form fields, keyboard only navigation, color contrast, use of headings, proper use of headings, even better, captions and audio description for video, lack of flashing content to trigger seizures, and not using color as the means of conveying information. These are the basic things that I look for when I'm dealing with a website or another piece of software that may or may not be accessible. Doesn't it sound simple? It is simple. All right, the laws we're going to talk about today: the Americans with Disabilities Act, my personal favorite, Section 504 of the Rehabilitation Act, Section 508 of the Rehabilitation Act, the Air Carrier Access Act, and the Affordable Care Act, Section 1557. A little bit about state laws and a little bit about international laws, but not very much because we don't have that kind of time.
Yeah.
So most of you probably know a good deal about the ADA, so I'm not going to run through the depths of it, but the ADA covers 3 titles: employment, state and local governments, and public accommodations. And big areas where digital accessibility comes up in employment under Title I is that you can't use qualification standards that screen out or tend to screen out employees with disabilities unless they're job related and consistent with business necessity. So if you're using an inaccessible technology that your blind employees or applicants can't use, you're imposing a qualification standard on them. So you're imposing a site standard on them that's actually not necessary for the job. It's only necessary for your choice of technology. And that doesn't make it job related and consistent with business necessity. And we are now coming up with those cases all the time where the employer has bought a technology or a bunch of technologies that can't be used by people with certain disabilities. And therefore they want to say, I can't hire you. My technology won't work for you. And I say, yes, you can. And it's not my client's fault that you made this mistake in choosing your technology. And if you're not going to fix that technology, which would be the smart approach, you're going to need to reasonably accommodate your way around that technology. And I, by the way, don't care how much it costs anymore, because you could have avoided it by choosing the right technology in the beginning. Yes, Sharon.
So I do have a question on that, because, you know, Nobility also advises people.
Right.
You know, you tell them to use, you tell them to get VPATs, you tell them to ask for,
Oh, sorry.
I'm sorry. This is Sharon Rush, and I wanted to ask Eve a question about exactly that, because
That business of buying accessible technology for staff in order that people with disabilities can be employed equitably
Mhm.
is really problematic when,
huge.
I mean, because you might notice that we use the Zoom events platform for the hybrid part of our conference, because we have tried every single standard conference platform. And, you know, when you ask for a VPAT and they don't know what you're asking for, you just figure, okay, never mind. But even when you ask for a VPAT and they give you one, and even when those VPATs are often honest, you still don't, I mean, they say, well, we're working on this and we're not there yet, and they're partially compliant. And so I'm just wondering if there's, I'm really glad to hear that you say, okay, we don't care how much it costs. You've had enough time. I mean, because think about it, it's been what, 20 some years since the first WCAG. People have had time to understand that. But what does an employer do in the case where I need an HR management software and I honestly can't find one that meets accessibility requirements? So that's
Sure.
what do you advise in those situations?
So we actually have that problem. In the law firm space, there are a lot of legal technologies that aren't accessible, and we want to use them. But we have a policy that all of our technology is going to be accessible because we hire people with disabilities. So we ask and ask and ask and ask, and there are some, and eventually someone will say, yes, ours is accessible. Give us a VPAT and show and make it work. But not all the time. There are some things we have still not been able to find an accessible version of, and we figure out how to reasonably accommodate our way around that. And it becomes a different standard because it's the technology's fault, not something inherent to the job. That means that we have to reasonably accommodate our way around it, but it increases the employer's obligation to accommodate around it.
Thank you. Hi, this is Peter Slayton. And my question is, you are suing perhaps an employer, but the software manufacturer or software designer producer is, you're
Often,
asking instead of saying, make
right.
your technology accessible. Why is that?
Because the software providers, the vendors, are not covered under the ADA. So that's one of the laws we're going to talk about that would fill that gap. So
Thank
what
you.
I get this with schools a lot. They say, well, I didn't make the technology, I just bought the technology. And I say, well, you made a mistake. Very often there was an accessible technology, you just didn't buy that one. But the other thing is, and they say, but it's not my fault, it's not my fault, it's their fault. And it's like, yes, it is their fault. And if you had a clause in your contract that said your equipment has to be accessible, then you would have a cause of action to go after that vendor. I don't. I would use it if I had one, but you do, or you could have if you had a strong procurement policy. Yes.
Hi, I'm Seda Mauer, and I have a question about how often and how frequently should people go to court or bring litigation against people who are not hiring people with disabilities. I had a friend who was legally blind, and she was just a wealth of knowledge, but they would not hire her because she needed special equipment, or when they hired, they made her life so miserable that she had to quit. So does she have to keep going to
Yeah.
court constantly?
Unfortunately, the way it's set up, when you are discriminated against, you have to go first to the Equal Employment Opportunity Commission and exhaust, and it is exhausting, your administrative rights, and hope that the EEOC will investigate and get a resolution for you, or will take your case for litigation. You have to go through that process, and then you can go to litigation. But there's really not much else available as a legal recourse. The EEOC will send you to mediation. They'll often pressure the covered entity to do the right thing, and periodically they'll actually litigate on your behalf. Yes.
Hi, Eve, Phil Jenkins. Hi.
Hi.
There's a discussion going on out in some of the blogs right now about a user who chooses to or can't afford a screen reader and uses a free version. So for example, they might use NVDA, which is a free screen reader.
Right.
Or they might use, perhaps in another country or in an area where there are bandwidth issues, might use a text-only browser.
Yeah.
So the disability is not the issue. It's the AT that's between them and the website. And so if the website uses all the latest technology that's been around for 10 years, JavaScript and CSS and things, but it's not supported by their chosen assistive technology, do they have standing? I didn't know
They
what the thinking
do.
was, and how
It's
it fits
They
there.
do. They do have standing if their choice is reasonable, basically. Because if you make your website accessible, it should work with the updated across the board approaches to screen readers. It may not work with the older versions, and that's a problem for people who can't keep their versions up to date. So that becomes a real problem, and we have trouble because you can't just say it's not accessible to me. It has to be both not accessible to you and not accessible in a more general, objective way. Yes. Microphone.
Hi, Andrew Puckle. So hypothetical big company makes internal tools is for employees. Said company's legal team believes rightly or wrongly that it's not public and therefore it's the legality of it. So the argument is that they don't have to make it accessible because it's for it's not public, right? So it's internal, right? So it's not employees. So what is the
Sorry. Did
I get that all the time. So
no, they're making tools for their employees to use. They have to be able to hire employees who can use them. Those things they have less defenses than the ones who use a vendor.
CHLE.
Because they have less defenses than the ones who use a vendor. You got nobody to blame but yourselves, not you personally. But no, because being private, if you're a covered employer, meaning you have 15 or more employees, you have obligations not to discriminate against those employees, and using your technology to screen out those employees is discrimination.
So the tools they're making are screening them out, even if they provide training or accommodations.
They better be accommodating them really well, because the problem is most accommodations around a technology involve an extra human, which tends to be expensive, and nobody wants to do it. But if you made your technology inaccessible, foolishly, then I don't care how much it costs. You need to accommodate your way all the way around the inaccessible technology. So that means, no, my person doesn't get to use the technology that everybody else uses 8 hours a day for 1 hour a week, because that's the only time we'll give them a reader, for example. Okay. So that was the other piece. You have to be prepared to reasonably accommodate your employees. In other words, if you're working around an inaccessible technology where you could have gotten an accessible one, I don't care how much it costs. But there is no technical accessibility standard in Title I. You'll hear that refrain a lot. Title II covers state and local governments, and the requirement here is equally effective communication. Whatever the government communicates, either internally or either out to the world or in from the world, has to be equally effective for people with disabilities and people without disabilities. If people without disabilities can get it on demand, then people with disabilities have to be able to get it on demand. The same information, same timeliness, same ease of use as people with disabilities. And the way you do that is providing auxiliary aids and services. But accessible web technology or accessible digital technology is an auxiliary aid or service. So in order to be effective, those things have to be provided in accessible formats in a timely manner, meaning same time, relatively speaking, as other people can get it, and in such a way as to protect the privacy and independence of the individual with a disability. So I'll get this a lot of times. Well, they can just call me and I'll read them the website, to which I roll my eyes because I've seen sighted people get tired reading the menu in a restaurant and say, oh, this blind person doesn't look like he likes salad, so I won't read those anymore. There's no way they're going to read you the whole website. And it doesn't protect the privacy and independence of the person. We go through our website, we pick what we want, we put it in our shopping cart, we check it out, we give our credit card number to no human whatsoever, and we're gone, and nobody knows what we bought, however shameful it may be. But the blind person is supposed to tell you what they bought, have some human know what they bought, and have some human know their credit card number and every bit of detail about it. That's a difference in privacy and independence. We talk about this a lot in the voting context too. When I have to have a third party read my ballot to me and then mark my choices, I've given up the privacy of something that's very private, and I've given up my independence. And those are the things that make it not an effective auxiliary aid. So having a third party read something to you can be an effective auxiliary aid, but not if it's something that it requires revelation of something private or loss of independence. But again, there's no technical standard. So people say to me, well, what if I don't meet WCAG? And I say, well, WCAG's not the standard. What you have to meet is that your communications are equally effective with people without disabilities and people with disabilities. If you can find a standard other than WCAG that accomplishes that, cool. You'll have to prove it, but cool. But there isn't one. And then Title III covers public accommodations, which are 12 categories, most of the businesses that people deal with regularly. And their obligation is very similar. It's effective communication. Same thing, you provide auxiliary aids and services, meaning accessible formats, accessible digital technology. And they have to be provided in a timely manner in such a way as to protect privacy and independence. But again, there's no technical standard. So if you can find a standard that works, other than WCAG 2.1 level AA, you are free to use it. Good luck to you. Let me make sure where I am. So if a covered entity provides information or receives information online, it needs to ensure it effectively communicates that information to people with disabilities. There is some dispute, or there's a question unresolved about whether a telephone approach is going to be allowed by the courts. No court has yet decided that. In the Robles versus Domino's Pizza case that I'll talk about in a little while, that question came up. Domino's said, well, we have a line you could call and you can order your pizza that way, except the line takes a 45-minute wait. And as the judge found, no one who's ever been hungry or ever wanted a pizza would find that to be equally effective as online ordering. And then while there is no standard in the law about what accessibility means, other than that it has to be same time, same place, same information, substantially equal ease of use, DOJ and other federal agencies, the federal Section 508 and courts have all said that compliance with WCAG 2.0 or 2.1 level AA establishes effective communication. So if you meet WCAG, you're meeting the effective communication obligation under the ADA. A little bit on defenses, you've got to document them in writing. Defenders get tripped up on this all the time. It's an undue burden, it's an undue burden. Like, where'd you write that down? Good for you, it's an undue burden. We didn't write that down. We're writing it down now. Too late. So it has to be documented in writing by an official with the budgetary authority to say, I have the money, we can fix it now. And you can only have a defense of undue burden, meaning it would be much, much, much too expensive for you to do, or fundamental alteration, meaning it would undermine the point of the device, the point of the goods, the point of the facilities, the point of the privileges, advantage, or accommodation being offered. And even if it's an undue burden or a fundamental alteration, the business still has to offer whatever alternatives would not be an undue burden or a fundamental alteration. Yes.
Walton, so going back to the undue burden, that's something I both see and challenge internally.
Right.
Also undue, hardship. But to that point,
Same
is
thing.
there I'm saying bright line in terms of by company, what is too expensive? I mean,
Yeah.
what have you seen? What have you, the conversations, how is that interpreted? Because it's really broad.
It's rarely interpreted. So most cases settle. So we haven't got, and there are no bright lines in the ADA. So there are no bright lines, but it has to be you look at the cost of this in light of all the resources available to the company or to the entity. So it's not just you don't compare, for example, the cost of the accessible technology to the salary of the employee who with a disability who's going to use it. No. You compare it to all the money that the employer has, basically. Compare it to all the money that the state or local government has that it could put to use to this purposes. So it costs quite a bit before it becomes an undue burden. Yes. Waiting for the mic.
Hi, Peter Slayton again. Thanks. So from the user viewpoint, the blind person or otherwise disabled person who's using a website, I worry when I run into trouble, is this problem because I don't have the skill set?
Right.
And do I have standing in that case? Or is it because will they say, I'm sorry, you're just not equipped. This is perfectly accessible and you don't know
Right.
how to use it.
Well, it's both, really. It has to be not user error that makes the thing inaccessible, and it has to be not I have the oldest technology in the world, so it won't work for me. So when I take on a case, I both insist that the user have been affected, so it can't be just a automated WCAG test that had a lot of barriers. It has to actually have impacted the user and actually have made something harder for them. And I have to do expert testing on it as well to make sure that it wasn't just user error or a technology fault on the user's part.
This is Dinesh here. So, for example, if there is a well documented process and accessibility policies, everything, but purchase inaccessible product for just a few staff, but how that well documented process would help if that goes to the court?
If they in fact chose, you've got a well-documented process, you've got a procurement policy, you do all the right things, and they still let something through without documenting an exception, there's no good faith exception or no good faith defense to the ADA. It may help to be able to say, we tried as hard as it's possible to try, and so this just slipped through. At least the judge won't be mad at you. But it's still not a defense that we tried and messed up. You tried and messed up. Okay, I want to talk about federal agencies. Now, this picture is at the 504 demonstrations where they took over the Department of Health, Education and Welfare back in the 70s to get the Section 504 regs promulgated. Section 504 applies to federal agencies. We forget that it applies to federal agencies. The federal agencies have their own obligations in terms of digital accessibility, and to recipients of federal financial assistance. And this is where we usually do it. Yes.
Thank you. This is Rachel DiTullio. I've been looking for this answer and can't find it. Are members of Congress's websites considered part of federal agencies, or is this just stuff that's under the executive branch?
Just stuff that's under the executive branch. I'm sorry. I can't tell you how sorry I am. Congress first exempted itself and then semi put itself back in, but not really. So there's nothing we could do about it when their websites are not accessible, except maybe when they're campaigning, because that's different from their official website, because then they're hosting events and stuff. And that hasn't been decided, but maybe then they're a place of public accommodation and have to do better. Okay, so mostly we apply this to recipients of federal financial assistance, and this is anybody who gets any money from the federal government, not contracts mostly, but grants. So every educational institution from elementary school through colleges and universities usually get some federal form of financial assistance, if only federal financial aid to their students, and that counts. Lots of grants from HHS, the school lunch program, lots and lots of, there's lots of money flowing out to lots of entities that you wouldn't even think. Medicare and Medicaid count, for example, as federal financial assistance. Tax credits count as federal financial assistance. So we'll talk a little bit more about that. But it applies the same equally effective communication standard as Title II of the ADA. So it has to be equally effective between people with disabilities and people without disabilities, and the same defenses as the ADA. So that makes it very handy, but it applies to more entities than the ADA, or different entities than the ADA may apply to, because you don't have to be a place of public accommodation if you get federal financial assistance. But it doesn't, for the most part, cover employment, except if the program is about employment. And then federal agencies, we look to Section 508 of the Rehabilitation Act. Section 508 says technology that is developed, bought, or used by a federal agency has to be accessible. So any federal agency worth its salt is putting in its procurement contracts that your contractors have to make the technology that they're creating 508 compliant. And that uses WCAG 2.0 level AA.
And do you find that they are?
No, they're not doing it at all. A report from the Justice Department and another report from the GSA came out to indicate and showed agency by agency how poorly they're doing. Some are doing better than others, but they're overall poor. And there were sort of two things to look at. First is website accessibility, and then the PDFs on their websites, disaster. Which led me to the conclusion that stop using PDFs. just stop.
Does that include things like printers and copiers?
Never mind, because the people at home.
Thank you. Does that include equipment like copiers and printers, scanners?
Yes, it does. It includes all the equipment, all the electronic and information technology equipment that they buy. So that involves the computers, the copiers, the telephones, and so forth. And I've encountered federal agencies recently who thought they were complying with 508. I don't know how, because it says all technology purchased, bought, or used, developed, bought, or used has to be accessible. They decided, well, we'll buy a bunch of inaccessible phones, and then we'll buy 5% of our phones will be accessible. They have no mechanism for getting the accessible phones to the people who need accessible phones, but they've got 5% of them probably somewhere in a closet. Not what it requires. It's just not what it requires. And they're failing shockingly badly. I testified at a hearing about it in November, I think. But we'll have good news about that in the rest of the presentation.
Okay.
Okay. The newest law in this space is the Affordable Care Act. Section 1557. And that applies to all recipients of HHS, the Department of Health and Human Services funding. So if entities get Medicare or Medicaid, and that's a lot, then they also have to comply with the equally effective communication standard. And if they don't, it's a potential false claim. And the False Claims Act means that the government can get back all the money it paid to the person who was lying in their claim that something was accessible. And the relator who identifies the false claim can get, I think, 1/3 of that money as a bounty. Yeah, be on the lookout and call me. We can help with that. All right, and then the Air Carrier Access Act, which unfortunately can only be implemented by the Department of Transportation, not by private people, requires airline websites to be accessible to WCAG 2.0 level AA, and weirdly requires airline kiosks to be accessible, or at least requires 25% of airline kiosks to be accessible, but providing speech output, tactile input controls. But I don't know how the blind person is going to find the 25% that are accessible, because it's just a little weird. But that's where we are. And then there are a variety of state laws. You hear more about these in terms of litigation. The strongest state laws are in places like California and New York, where they provide for damages. Now that's something I didn't mention about Title III of the ADA. You cannot get damages under Title III of the ADA. You can only get injunctive relief and attorney's fees, which is an incentive for them to comply. Some go beyond the ADA. California and New York both go beyond the ADA. They say the ADA sets a floor, and anything, and they can require beyond. And then there are state-funded technology acts, mini 508s, we call them, in a variety of states that often require WCAG 2.0 as their standard. Yes.
This is Kate Pascal, and I have a question about like which state you would be applicable. Is that like where your business entity is associated with, or how does that work?
Yeah, it can be wherever the person is, actually. So we'll talk a little bit more about that when we talk about the circuit splits. And then we have a variety of international laws. I am not an expert. I'm kind of an expert on the Canadian international laws, because they're a really interesting way of approaching it, or at least the accessibility for Ontarians with disabilities is an interesting way of approaching accessibility. And I'm looking forward to seeing how it'll play out, because the government can enforce it, and you can get fines up to $250,000 per incident, which I think is a pretty strong, well, $100,000 under the Ontario's Act, $250,000 under Accessible Canada, which could be a pretty strong incentive for making things accessible if it would be enforced. And that remains to be seen. Okay, a little bit about regulations. These are the things I've talked about. Most of the standards that we apply are in regulations for the ADA and the Affordable Care Act. But the guidance is getting to be where it's at, because regulations take forever to go through. We're all waiting for an ADA Title II regulation that we've been waiting for since I was at the Justice Department. So since I can't even say this in a good way, since forever. It takes a long time. But in the meantime, entities put out guidance. So HHS, the Department of Education, and the Justice Department have all put out guidance indicating that WCAG 2.1 or 2.0 level AA meets the effective communication standard. So no question about that. And then DOJ in 2022 put out guidance. That's the website address. It's on their ada.gov website now. That addresses both Title II and Title III, and confirms that the standard is effective communication, and acknowledges the WCAG and 508 standards, and confirms that DOJ is going to continue to enforce digital accessibility. And they have been enforcing digital accessibility. If you had another question.
Yes, this is Seda Maurer again. When you're saying guidance, you just mentioned enforcing it. Is it a mandatory guidance? Well,
Right.
Can you distinguish between guidance and mandate?
Right.
Because Department of Transportation mandated
Yes.
it and attached penalty, but what does DOJ?
So
do?
there's a difference between regulations and guidance. Guidance is advisory, and it says to people, this is how we as the Justice Department will enforce this law. But the guidance is not, the court won't necessarily enforce the guidance. It's due some level of deference, Skidmore deference, they call it. You'll be hearing more about this in the news as all of these things work their way up to the Supreme Court, sadly. But they're entitled to some deference unless they're clearly irrational. The courts will give the guidance some deference. Regulations get a lot more deference. They get Chevron deference. So regulations are enforceable by the courts. Guidance is just persuasive to the courts. And then DOJ and EEOC have both issued guidance together on artificial intelligence in hiring. First, DOJ, EEOC, the Consumer Financial Protection Board, and the Federal Trade Commission issued guidance saying that they can and will enforce non-discrimination laws against discriminatory uses of artificial intelligence. That was very strong to get all four of these agencies to be rowing in the same direction on AI discrimination was great. And then DOJ guidance came out on algorithms, artificial intelligence, and disability discrimination in hiring, and really brought to forth some of the key problems that we are facing and are going to be facing in employment and use of AI. That some hiring tech tries to predict who will be a good employee based on current successful employees. And people with disabilities have been left out of the workforce pool, so they won't be represented in that current employee workforce pool that the AI is learning from. So employers have to avoid using technologies that do that kind of discrimination and must evaluate the information used to build the AI technologies. This is going to be very hard for the employers themselves. And once again, I can't get the vendors under federal law. DOJ may be able to get the vendors under federal law, but I can't. So the employers are going to have to really be cognizant of the fact that if they're buying an AI tool or the use of an AI tool, using an AI tool, it's their obligation to make sure that that tool has been tested to include people with disabilities and to not discriminate against people with disabilities. And I don't know how they're going to do that because no vendor is going to tell them. They're going to have to force feed people with disabilities into that workforce pool. And then other technologies screen out or tend to screen out people with disabilities by using screening mechanisms, by being inaccessible, basically. That's imposing a qualification standard. And you can only do that if it's job related and consistent with business necessity. So voice analysis or facial analysis is going to screen out people with autism or speech disabilities. And that's illegal as well. DOJ points that out. And then assessments that are all the rage now have to test job skills, not disabilities. If they test the disability, that's a discrimination as well. And finally, you have to provide reasonable accommodations for your assessments and your AI tools and your screening mechanisms. And most of the ones that I've seen don't even have a way to seek an accommodation, let alone a process for getting one. And they don't tell people in advance what the technology is going to ask them to do. So the people don't even know that they're going to need to ask for accommodation until after it's all over. So DOJ, if they take themselves seriously, are going to have a lot of work to do. And then the EEOC guidance, similarly, this is part of it has an initiative on artificial intelligence and algorithmic fairness that I won't go through it all. It's a question and answer format. It's really quite comprehensive, but a plain language walkthrough. And then DOJ and HHS came out with guidance on telehealth and how that needs to accommodate people with disabilities and people with limited English proficiency. And it also emphasizes the effective communication requirement. All right, laws on the horizon. The Website and Software Applications Accessibility Act has been reintroduced this year. And it clarifies that the ADA covers websites and apps, including those of online-only entities. There's some controversy about whether an online-only entity can be a place of public accommodation. Some courts think place means physical place, that you have to have a physical place. And I'll talk a little bit more about that. This says no, if you're an online-only entity, your website is covered and has to be accessible. And it defines accessible very similar to the way I define it, and incorporates the WCAG principles: perceivable, operable, understandable, and robust, that enables individuals with disabilities to access the same information as, to engage in the same interactions as, and to communicate and to be understood as effectively as, and to enjoy the same services as are offered to other individuals with the same privacy, same independence, and same ease of use as individuals with disabilities. So that's concept of the same privacy, independence, and ease of use is really important. This would also get to the vendors. Did I put that on here? Yes. So it would cover the developers of websites and apps. So no longer would I have to say to the educational institution, well, you should have put it in your contract, and then you could go after them. I could say, okay, I'll go after them too. And it requires them to provide accessible websites and apps. The defenses are still undue burden and fundamental alteration, and it requires DOJ and the Equal Employment Opportunity Commission to issue regulations setting accessible standards within a short period of time. So it can't go on for 10 years like the DOJ regulations have had. And it requires monitoring and reporting on compliance. It's quite a strong law. It's getting more co-sponsors all the time. We'll see if it makes it through Congress, but it's quite a strong law. It would help a lot. It also provides a private right of action. Both DOJ can enforce it, a private individual entity or class, or a covered entity. So my educational institution that I'm giving a hard time because they bought something from the vendor, they can go after the vendor under this law, not just under their contract. So it wouldn't even have to be in their contract anymore. And it provides for damages. So as I mentioned, Title III of the ADA doesn't provide for damages. This does, both economic and non-economic damages and punitive damages, as well as injunctive relief and attorney's fees.
What is the tentative name for this? I just like to be able to recognize it. Thank you.
The Website and Software Applications Accessibility Act.
Hi, this is Lori Merriman. I have a question. So in the public sector, we've had Section 508 since like 98.
Right.
Is this now the potential act that would enforce the private sector as well?
Yes.
Okay. So this is like our first
Well,
legal.
it takes the ADA and goes further.
Yeah, right. Okay. Okay. Thank you for the clarification.
All right. And then I got to watch my time here. There are updates to the Communications Video and Technology Accessibility Act. Well, the Communications Video and Technology Accessibility Act would update the 21st Century Communication and Video Accessibility Act, CVAA, which did a great deal in the telecommunications and video space. This would expand the requirements and standards for captioning and audio description, require reports and regulations on emerging technologies. Both of these acts are pushing the government to keep up with emerging technologies, which they have been failing utterly to do. Requires entities that offer user-generated video to offer easy tools for captioning and audio describing the videos. So these are the things like YouTube. It would be required to let its authors and make it easy to use it for its authors to audio describe and caption their videos. Yes, you had a question.
So I'm with this Kate Pascal. This is the CVAA as it is currently, or it's going to be updated?
No, it's updated by the CVTAA.
Okay, so I know that video games were given an extension by
Right.
about 10 years, which I think was too long. Do you foresee that happening again, or will they automatically be included?
They won't automatically be included because they're subject to the extension already.
Do you have a potential time frame on
No, I
how?
don't.
Okay, we'll stay tuned.
Don't
Thank
even
you.
know when it'll be passed. And then it sets standards for visibility and location of sign language when it's provided in video, so that we can get some consistency about where the sign language will be. And then regulatory developments. This is the one we've been waiting for approximately ever. In 1996, DOJ came out with a statement saying websites are covered, that they are communications and subject to the Effective Communication Standard. In 2010, they put out an advance notice of proposed rulemaking only for Title II, state and local governments. In 2015, they put out a statement saying they were going to do a notice of proposed rulemaking for Title II. In 2016, they said, no, we're going to do a supplemental advance notice of proposed rulemaking for Title II. Right now, their unified agenda says that they will issue a Title II notice of proposed rulemaking this month. Knocking wood. So we'll all need to comment on that. We'll all need to work on improving it, strengthening it, applauding the things that are good, helping them do the cost benefit analysis. All those things will be really important. And this is only Title II. They have plans to do Title III as well, but this will set a lot of what we can expect for Title III. And then HHS and the Department of Education are also planning to issue regulations under Section 504, both of which will deal with digital technology as well. HHS is already late. They plan to issue their notice of proposed rulemaking in 2023, and it's not out yet. And DOE plans to do it in May of 2023, but I don't think they will. So I'm expecting they'll come out more in the end of 2023 and 2024. Yes.
Hi, this is Andrew. I just, based on your experience, obviously no one has a crystal ball. What do you think the likelihood of 4998 becoming law is, especially in divided government?
I don't think it'll come this, I don't think it'll go this year, but it gets stronger and stronger every time. That's just me. I'm a negative Nelly. Okay, self-service transaction machines, which we all call kiosks. The Access Board provided an advance notice of proposed rulemaking in September of 2022, asking what do we think about technology requirements for speech output, braille, and display screens. And they expect to put out an NPRM by the end of this year. So that would move us forward a lot, because currently the only things in the ADA are vending machines, and they only say basically, are ATM machines, sorry, and they only talk mostly about, well, they talk about a number of things, but it's only for ATM machines. All those other ticketing machines are unregulated essentially at the moment. So that could make a big difference. This is a long-term strategy. When they come out with a rule that only applies to the federal government at 504, it doesn't apply to the ADA. So the DOJ then has to pick up the rule and enact it itself in order for it to roll out to the rest of the country. Yes.
So Phil Jenkins, does this also include vending machines?
Yes.
Okay. So it's more than just the kiosks. And
Yes. Self-service transaction machines.
okay.
All of them.
That was a stumbling block on the Access Board.
Yes, it
10
was.
years ago.
And a stumbling block for the McKee court with Coca-Cola vending machines. All right, now we can get to cases, my favorite part. As I mentioned, there's a controversy, and not exactly a split, but the rumor of a split on whether you have to have a physical place in order to be covered by Title III. So is an online only business covered at all by Title III? So far, the only court to directly take this on is the Ninth Circuit, and they took it on in the Target case, but they most recently confirmed in Robles versus Domino's Pizza, one of the cases I was involved in, that as long as there is a nexus between a physical place and the website has to be accessible. The 11th Circuit almost made a decision in Gill versus Winn-Dixie, where it found there has to be more than a connection. There has to be more than a nexus between the website and the place. that the website has to have interfered with your ability to get stuff at the place. And then the plaintiff sought rehearing en banc, which means the whole court would hear it. And then the plaintiff said, oh, but wait, it's actually moot. And the whole court said, you're right, it's actually moot. And they vacated the whole thing. So the appeal is vacated. The panel that decided the appeal is vacated. The district court decision is vacated. We went through years of court, all to come out with nothing in the 11th Circuit. So we really don't know. But that one panel said, oh no, it's got to be hard. It's hard to cover a website. The First Circuit has not decided a web case, but has decided an insurance case and said, no, you don't have to be a physical place of public a physical place in order to be covered. So they would indicate that websites would be covered even if they're an online only business. And then other circuits have taken somewhat different approaches. The Second and the Seventh, not in web cases, have indicated that you don't need a place. Like the First Circuit, they've indicated that you could be online only and still be covered. The Third and the Sixth, not in web cases, have indicated that they would follow the Ninth Circuit, that they would require a nexus between the physical place and the website. And the Fourth, Fifth, Eighth, and 10th, we got nothing. We don't know. But what I ask everybody is your website only in the Third Circuit? No, it is not. And people all across the country can sue your website where they are because you're doing business where they are. So, I advise people to sue in the First Circuit, where online entities are covered. Yes.
Hi, this is Chris Law. I think looking out into the future, it's inconceivable that the Nexus people will win.
It's inconceivable?
Inconceivable.
Why is that?
Because of just the way that the way that technology is going. There was presentations this morning about bank branches in virtual spaces that
Right.
you can go and make an appointment. So what's the point? What's underlying the resistance, do you think?
Defense attorneys. It doesn't even make sense half the time. Like Domino's said, well, we're not a place of public accommodation. Of course you are.
But surely these people are playing it out in their heads as to what the future is going to bring. They watch the news.
No, they're
surely?
not.
No,
No.
no, they're not in tune. Okay.
They're not into the technology at all. They have a website because they have to have a website. They slapped up a website, whatever. Okay. And then we have a little bit in the Court of Appeals in California. We had hopes because the California law goes beyond the ADA, or at least can go beyond the ADA, that they would come down hard and say that website online only businesses were covered under the California law, but they did not. The first Court of Appeals to deal with this said there are only two ways to prove a California Unruh Act violation. One is by an ADA violation, and they decided to follow the Ninth Circuit, even though they didn't have to. So Cotton Wash was online only and didn't have a nexus to a physical place. So they found that it was not an ADA violation to have an inaccessible website. And then the other way to prove a state law discrimination claim was if the discrimination was intentional. And even knowingly having an inaccessible website did not constitute intentional discrimination. I'm not entirely sure why, but it did not. They said the website itself was facially neutral. It didn't intentionally discriminate. It just left them out by accident. So that was concerning. We've been very busy in the education space over the past year. Things like the University of Chicago entered into a settlement through structured negotiations to improve digital accessibility for both employees and students. This covers all their electronic and information technology, websites, forms, apps, system-wide policy guidances and procedures, procurement, training, complaint processes, hiring a person to be in charge, appointing an advisory committee, and paying $12,500 in damages and $40,000 in fees. So it wasn't cheap, and they have to do a lot of work. Los Angeles Community College District, another case that I'm involved in, has been going on for forever and a day. LACCD had a policy that said they would use only accessible stuff. They would buy only accessible materials, and they would make all their books accessible. It was great, terrific policy, and they didn't follow it at all. So they used inaccessible course platforms and materials, and they were unable to, on a timely basis, make class materials and textbooks accessible. So our two blind clients could not get through their classes. They just couldn't do it. So it went to trial once, a couple of years ago, and the decision was in favor of the plaintiffs, and the court ordered LACCD to make its stuff accessible within a year. And the educational institutions across the country collectively went, because that was fast. And then the LACCD appealed to the Ninth Circuit. The Ninth Circuit found that disparate impact was cognizable under Section 504 and the ADA. So we didn't need intentional discrimination, which is good, because some people are looking at, oh, it's not intentional to have an inaccessible website. So, but they kicked it back because the trial court was confusing in his decision. So we remanded for a new trial, and that new trial is happening this month. So we'll see what happens again. It's a little hard to see how it's going to turn out differently, but one never knows. And then UC Berkeley, this was a Justice Department findings letter and consent decree dealing with the inaccessibility of their publicly available online content, like MOOCs through edX, their YouTube lectures and their iTunes U lectures. They were inaccessible to people who were deaf or hard of hearing. Many of the MOOCs didn't have captions or any way for the blind to access the visual materials. The YouTube lectures had no captions or used automatic captions that were so bad that you couldn't really use them. And none of the iTunes U videos had captions or audio description at all. So Berkeley agreed to adopt procedures to require Berkeley staff to comply with WCAG 2.0 level AA for all online content, make all online content on the edX platform and all Berkeley platforms accessible within 9 months, and make all their websites accessible within 18 months. And then going back to existing audio and video content on the website and their podcast platforms to make all of that accessible within 3 years, in addition to hiring, providing a mechanism to get feedback and to respond to that feedback within 28 days of receipt, and to hire an external auditor. So very robust remedies there. And Berkeley Unified has a settlement now that requires any new technology purchases to be reviewed for accessibility by several different departments, and the technology cannot be purchased unless it meets the accessibility requirements. And then CUNY, this was again with the Justice Department, they used a third-party online learning products for their mathematics course, namely WebAssign, which was not accessible, and then they couldn't reasonably accommodate their way around it. They couldn't provide the materials in accessible formats on time. So they agreed within 150 days to implement CUNY-wide policies to make sure all course materials are available in accessible formats by the first meeting of the first class. And then to ensure the accessibility of every third-party and online learning product, platform, or app that they use will be accessible prior to its use in any class. So it's pretty strong again. Employment, we have several cases working their way through the EEOC regarding customer service technology accessibility. Customer service technology that the employees use to provide customer service for websites, for the most part, is shockingly inaccessible, although there are accessible versions out there. So these employers have made a bad choice. They make the cases make the point that an employer can't purchase or use inaccessible technology and then refuse to hire blind applicants, or to accommodate those blind applicants by providing the staff that they need to help them use the inaccessible technology. And then another case before the EEOC makes the point that this is again in the customer service. This is a company that hires employees for other companies to run their customer service. So they outsource the customer service function. And that this case makes the point that an agency that hires agents for other companies can't refuse to hire blind people because they think their customers' technology is inaccessible. And I've sort of said to them, well, either you're going to take the hit for this, or you got to turn over your customers and they can take the hit for that. But somebody's taking the hit for this. Then we talked about AI hiring. I want to do some of that too, but not just for the EEOC and the Justice Department. Why should they have all the fun? And then Orozco is a very recent case. The question was whether or not there was a private right of action for federal employees to enforce Section 508 against their federal agencies when their technology was not accessible. And the DC Circuit held that there is a private right of action. So all those agencies whose technology has been so terrible in the federal government, now their own employees can take them to court about that. So I expect we'll see a good deal more enforcement of Section 508 in court going forward. Kiosks have not been left out in the dust. Both Quest Diagnostics and LabCorp have been sued through class actions, and those are making their way through trial right now. Those were check-in kiosks. And in entertainment, a couple of new developments. Panera versus HTC. HTC was a virtual reality subscription service like Netflix for VR. And the court held that it was covered by Title III of the ADA, even though it was online only. And they recently reached a settlement under which the service will caption all its VR offerings and revise developer guidelines so that to require captions for future games on the Vivaport Infinity platform. So much like Netflix did, they'll caption their own stuff and they'll require their developers to caption theirs. That's a big thing. And then the National Association of the Deaf sued SiriusXM and Stitcher and Pandora podcast platforms because they don't provide transcripts of their podcasts for the deaf and hard of hearing. That's still working its way through the courts. Yes, Peter, we'll get you the mic.
Thank you. If you're going to cover this later, never mind, but there's a case about standing, how many hotels, I think it is, standing to sue.
Oh, oucher, the Alford case. I don't want to talk about it. Do I have to talk about it?
No.
There's a case that's going to the Supreme Court about standing and whether testers have standing to challenge inaccessible websites. It's really about whether testers have standing to challenge the obligations that hotels have to put photographs and descriptions of their accessible hotel rooms on their websites. And this tester didn't really want to go to any of these hotels, but went to their websites she does use a wheelchair, went to these websites to see if they had the information up. And when they didn't, she would sue them. And there's now a split in the circuits about whether such a person has standing to sue when they didn't really intend to go to the hotel. And this is a big deal because a lot of discrimination you can't tell just by looking. So housing discrimination, for example, testing is really often the only way to uncover housing discrimination. Testing is often the only way to uncover employment discrimination. So it's really important that you have standing for testers to be able to challenge these things, or you lose the ability to force them at all. So this is going to the Supreme Court, and it's going to be great. I have faith. And then a little bit about overlays. Yes, okay. That's the reaction I expected. As we all know, there's a controversy over whether, well, there's really no controversy, but overlays don't necessarily fix the problems of accessibility. So settlements, at least, not courts so far, but settlements at least are providing explicitly that overlays do not satisfy the accessibility requirements of settlements. And one of the key ones was the Lighthouse versus ADP Incorporated, which made one of the earliest ones. It's happening all the time now, that they'll explicitly say you have to make your website accessible and an overlay will not comply. So we're getting somewhere with that.
I have a question.
Yeah.
I was just curious, is it possible to sue an overlay company for fraudulent claims or anything like that?
Why, yes, it is.
Okay.
And I'm very interested in that case. You have to have the right plaintiff. Their clients are the best people to be plaintiffs in that, as opposed to people out in the world. All right, and then false claims. Our first false claims case on a website case has moved forward. This is a $66 million campground reservation website by the California Department of Parks and Recreation. The contract said, "Thou shalt make the website accessible." The contractor knew its software platform was not fully accessible and didn't remediate it and didn't tell the government that it was not accessible. And when it went live, it was inaccessible. So a relator, a person, a real human being, filed a false claims complaint in 2018, and the case could result in a return of the $66 million to the government, and as I said, a bounty for the relator for figuring it out and turning them in. This case is in the process of settling. So far, the settlement is not public. I don't know if it ever will be public, but it's in the process of settling. But this is what can happen with a state government website or a federal government website when the contractor fails in their responsibilities, particularly if they knew that they were failing in their responsibilities and they nevertheless submitted the invoices to get paid for something that was supposed to be accessible. And I'm very interested in those cases too, if any of you have them. All right, I am going to run out of time, so I don't want to go through this. You'll get the slides, but I wanted to talk just a little bit about best practices when we're talking to our clients, our consulting clients, or the people that we work for. One of the things that's really important is having implementation best practices, starting with policies and staffing and training, pre-posting procedures. I believe in bottlenecks, that things can't go up until they've been tested and found to be compliant. Procurement policies and actual bottlenecks for those too, and also indemnification if it all goes wrong. Remediation policies. How do you get remediation done? How do you prioritize it? What do you do first? And what are you going to do for the interim measures? So even while you're remediating, you need to have some other way for people to get the information that they need. What's the importance of audits? And then feedback loops are super important. People with disabilities will tell you what the priorities are by calling you and complaining about the things that they most need to use. And if you're responsive, that encourages them to be patient before they sue you. So it's a feedback loop, not a feedback black hole. So with 5 minutes left, do we have other questions? What did I forget to cover? Was I sufficiently shark-like, or did I try to be a dolphin? Yes. Vegetarian shark.
I have a quick question regarding AI. And how, if it's litigating against discrimination, just how on earth is going to be proven? Because the damage is so diffuse to say the rationale is not usually explainable,
right,
etc. So do you have any sense on how that a case can be mounted, even with fairly specific legislation on the books? Certainly the ADA guidance, which says that tells you to remove a particular element that relates to disability. I mean, it's so entangled, and you've got a diffuse, very particular profile, which you're never going to be able to match if you have a disability. So how do you think litigation will happen in this space?
I'm not going to tell you all my secrets about how I plan to do this, but I do plan to do it, and it involves testing. Testing is what you use for black box systems. It's just what you use for black box systems, and you match them up and you send them through and you see who comes out and who doesn't. And that will reveal the discrimination. It's the same, it's essentially the same best practice that they should audit their own stuff. I know. I'm in trouble because the AI expert is asking me AI questions. It's unfair. But I'm going to do it through testing, and I'm not going to tell you the details about how I'm going to do it. Yes.
One more question, then I'll hand it over.
Yeah.
It's similar to another question I asked, but I hear it a lot. So you buy a third-party app from a vendor, you bake it into something you're making, but the vendor's app is not accessible, but we're not reliable because the vendor's app's not. How does that work?
Say that again.
Okay, so you buy a component or
Mhm.
from a vendor, you bake it into something that you release to your customers,
Oh, yeah.
but then it's their app that's not accessible. How does that? Who's
And
liable?
you made it available to your customers. It's yours.
Okay, that's my question. Thank you.
Should have put it in the contract.
So again, that means it's not Microsoft and or open access. It's whoever uses such a
Right.
device or such a platform.
Yes, the vendor so far is not, well, I'm
Not
not gonna
yet.
give away all my secrets
Okay.
either, but there are some states where the vendor could be responsible. And the vendor could also be responsible for false claims if it's a government entity, and the vendor could also be responsible for indemnification or contract breach if it's a private entity and they actually had the sense to put it in their contract.
Do you have any keywords that should be in a procurement policy around, like, not just make it accessible, but specifying WCAG 2.1 AA, or is there, like, how specific do we need to get to enforce
Yeah,
this?
you want to get specific as to what standard you want. You want to get specific as to what testing they'll do, and that they'll give it to you to test yourself because don't trust them. That they'll give you their testing results as well as your own, and then what will happen if it turns out to be wrong. Those are the basic categories.
Thank you. Dwayne Walton, just to kind of piggyback on that, along with that, what about kind of their release cycle? Because I know vendors, some are only twice a year,
Right.
things. So you have any thoughts just regarding that as well?
Yeah, in settlements, at least, we've said to folks you're going to get your vendor to make this accessible in the next release cycle. So we have worked into the general release cycles or in the next 2 release cycles, whatever it took to do it. Despite the beauty of litigation, it cannot reverse time. Okay. Oh, we've got one more.
This is Lori. Going back to the overlays, what is the legal landscape up for that right now? Like, I'm a little blown away at how many sites I see are using
I
this
know.
and have been sold false advertising around accessibility. So where does that all stand today? I'm just curious.
Well, there's been no litigation that's gone through trial or through the court process about an overlay so far. There have been a couple of cases that started to be put together as sort of false advertising cases against the overlay companies, but you have to have the right plaintiffs to do that. So it hasn't gotten far in litigation so far, but it will, because the overlays, well, some overlays at least make some of the accessibility barriers worse. And so they're putting their customers at greater risk than they would have been if they just left it alone.
Like if the overlay, like if Coca-Cola got sued, but they said, well, the overlay company told us it would be accessible, then Coca-Cola goes to try to sue the overlay company, basically.
Right, Coca-Cola can sue the company. Coca-Cola could sue the company. We're picking on Coca-Cola, but it's hypothetical. Hypothetically, Coca-Cola could sue the company for breach of contract or for false claims.
I picked on them because they have an overlay.
Oh, do they?
Overlays being bad and use Coca-Cola as an example.
Oh, wow.
Nielsen Norman Group, the usability group.
All right, I
We have
am
one last
half a
question.
minute over.
We have one last question
Okay,
from
excellent.
Zoom. Amy Cole from Zoom said, is there any movement towards making voting more accessible, including more plain language for ballot issues?
There's not much, there's no movement that I know of to making plain language ballot issues. In fact, those are a political football every time with people trying to make them more complicated so that they'll be harder to come up with the right answer for. So not on that. We've been doing a lot of work on accessible absentee voting to make sure that that's at least accessible to people with vision impairments, mobility impairments, and so forth. And then there has been a lot of work in the past to make the voting machines at the polling places accessible.
All right, that's all the time we have for questions. Thank you so much, Eve, for the comprehensive update. Thank you all for the amazing questions. Pulling up onto the screen soon will be the QR code and link that would direct you to the course survey. Please make sure to fill it out. It will impact future Access U events. As a reminder, the session was 2023's Access U legal updates. If you need any help getting connected, please let me know. After you filled out the survey, you're welcome to head out and enjoy the rest of the conference. As an announcement, we will be having lunch in the Maybe Ballroom on the 3rd floor of the Ragsdale Center, followed by WAINU working together to advance digital accessibility. Thank you.
Okay. I can't answer your question. It's unfair.
As a litigant.
What?
The issue is, I mean, I think you could definitely show process is discriminatory.
Mhm.
But because the entire thing discriminates against any difference.
Right.
So but the single individual and whether in fact.
You never do it with a single individual. You do matched pairs and you do bunches of them because you have to show that it's a systematic program. problem.
But then you need to use a bounded cluster, which is not going to work.
What's a
right?
bounded cluster?
Oh, so the primary test for AI bias is a cluster analysis. What's the performance of the system?
I don't need to do any of that. They can explain the shit out of it. Doesn't matter.
Yeah.
I put through matched pairs of people with and without disabilities, and the people with disabilities didn't get through. That's discrimination. Your black box doesn't matter. to
So
me.
you match them on all but right, yeah. Okay, so you aren't looking at a single litigant, you're looking at, yeah, okay, good.
Yeah,
That's
no,
what-
I couldn't do it with
because-
one person.
Yeah, because
You
I
could
was
never
trying
get
to
it to it.
figure out how you would do that with, yeah, so that's great.
No, and the bigger a pool of matched pairs I have, is the better. So I need a really big one.
Yeah.
Yeah.
Okay.
Hi.
Hi, Jeff Klein,
Jeff.
a friend of Laney's.
Oh, good. Tell
Uh,
her I didn't embarrass her.
oh, no, it was great. It was great.